I will start with the grounds of appeal. The grounds on which this appeal is founded are: number one, the land justices of the Court of Appeal erred in law and fact when they avoided to adjudicate the substantial question of illegality, which was the basis of the respondents' appeal before them. Number two, the land justices of appeal erred in law and fact when they abandoned the grounds of appeal raised by the respondents and irregularly introduced new grounds of appeal that were not implicitly set out in the memorandum of appeal, and thereby erroneously ordered, that is, the striking out of the appellant's amended plaint in High Court Civil Suit number 43 of 2020, and further ordered a retrial on the basis of the original pleadings. Two, that the saving of the order for appointment of auditors, which order had been vacated and was never resurrected in the suit. Ground three was that the land justices of appeal erred in law and fact in finding that the respondents were never heard on the question of illegality in miscellaneous application number 654 of 2020 before their joint written statement of defense was struck out and judgment entered for the appellants. Ground four was that the land justices of appeal erred in law and fact in failing to evaluate evidence which was before the trial court and setting aside the judgment entered in favor of the appellants under Order 6, Rule 30 of the Civil Procedure Rules. Ground 5 was that the land justices of appeal erred in law and fact in ordering for a retrial of the suit in which the overriding question of illegality had been fully heard and determined inter partes by the trial court. Number 6, the land justices of appeal erred in law and fact in condemning the appellants to costs in an appeal where the respondents had not been purged of the illegality adjudged against them by the trial court. Number 7, the land justices of appeal erred in law and fact in rewarding the respondents with costs for committing an illegality. Those were the grounds. I'm now going to look at ground 2, which was considered alone. And I will read its resolution and conclusion. This was the resolution of ground number 2, which was considered alone in that lead judgment. These issues, save for the one on amendment of the plaint, flowed from ground 9 and 11 of the appeal. I am unable to fault the Court of Appeal for, in the exercise of its duty to re-evaluate proceedings of the trial court, noting glaring errors in the procedure adopted by the trial judge, the determination of which it deemed might have a bearing on the decisions of the trial judge. In the circumstances, the Court of Appeal was right in raising of its volition issues which merited consideration, albeit that they had not arisen from any of the grounds of appeal. The court identified such issues as the amendment of the plaint, the entering of judgment under Order 6, Rule 30 of the Civil Procedure Rules, and the legal basis for the orders granted by the trial judge, all done without conducting any hearing to determine inter alia whether the parties were in pari delicto and whether a cause of action can be founded on an illegality. In this, the appellant suffered no injustice whatsoever. Where the determination of these issues disposes of the appeal, there would be no need to proceed with any other ground of or issue arising from the appeal. In the premise, I find that ground 2 of the appeal, in which the appellants fault the Court of Appeal for raising issues outside the grounds in the Memorandum of Appeal for determination, devoid of merit, hence it fails. That's for ground 2. I will proceed to read ground 1, the resolution. In the matter here, for a resolution by this court is whether the Court of Appeal erred in declining to consider the issue of illegality raised with regard to foreign lending extended by the respondents to the appellants. And yet, this was an express ground of appeal. To determine this issue of illegality, it is necessary for this court to examine the decision of the trial judge on the matter and equally examine that of the Court of Appeal regarding the issues it raised of its own volition, owing to the resolution of which it came to the finding that it was unnecessary to consider the issue of illegality raised before the court. I will not read the analysis. I'm going to the resolution of ground 1. I need to point out here that it is incumbent on a superior court before which any question of or issue strictly of law is raised and does not require evidence to be adduced in support, to exercise prudence and pronounce itself thereon, instead of referring the question of law back to a lower or inferior court for determination. This owes to the fact that the superior court has the overriding competence to make an authoritative and binding decision on the matter. This position of the law is better appreciated when one takes cognizance of the reality that a question of law referred by a superior court back to a lower court for determination has the potential of returning to the superior court on appeal, thus occasioning avoidable delay and miscarriage of justice. Accordingly then, the Court of Appeal ought to have addressed and determined the issues of illegality of the credit facilities extended to the second respondent to the appellants therein, which was raised before it, and then refer the case back to the trial court for determination of the issues of facts. Therefore, in declining to pronounce itself on the issue of illegality of the impound transactions between the disputants, which was the crux of the appeal before it, and instead striking out the amended plaint for the reasons it has given, I find with the greatest respect to the Court of Appeal that it erred in law in doing so. Wherefore, I find that ground 1 of this appeal succeeds. Now, grounds 3, 4, 5, 6, and 7 were considered together. So I will read the resolution and conclusions covering those grounds because they were considered together. So for grounds 3, 4, 5, 6, and 7, the issue of illegality, as was raised by the appellants in their application at the trial court, failed to distinguish between the credit facilities advanced by the respective respondents to the first appellant. It was the loans advanced by the second respondent that the trial judge, in determining the objection, found illegal. He nonetheless disposed of the head suit, that is High Court Civil Suit number 43 of 2020 in its entirety, but without reference to the credit facilities between the first respondent and the first appellant, which were not affected by the issue of illegality. I concur with Madrama Izama, Justice of Appeal, as he then was, in his holding that if the impound transactions were found to be illegal, the trial court would have had to accord the parties a hearing to establish the parties' contributory liability in the commission of the illegality and determine the fate of the monies advanced under the illegal credit facilities. Second, the trial judge had ordered for the audit of the impound transactions and ascertainment of the status of the loans between the parties. Hence, he was under a duty to determine the aspects of the dispute between the appellants and the first respondent, arising from the loan the first respondent had extended to them, and over which the issue of illegality had not arisen. He, however, failed to do so, and instead made an omnibus finding of and order on illegality of all the transactions. His failure to conduct a trial in the head suit, where from ascertainment of all the facts pleaded would have been achieved by the parties adducing relevant evidence, offended the age-old cardinal rule that no one should be condemned without being accorded the right to be heard on the matter in controversy. His decision, therefore, occasioned a miscarriage of justice. Hence, ground 3 of the appeal fails. In the event I find no justification whatsoever to fault the Court of Appeal for its finding that the trial judge erred in entering judgment in the mine suit under Order 6, Rule 30 of the Civil Procedure Rules, when the matter before him was not for determination of the head suit, but rather an application whose resolution in the circumstances could not dispose of the head suit. The Court of Appeal was thus right in setting aside the orders of the trial judge and ordering for a retrial of the head suit before another judge. Accordingly then, grounds 4, 5, 6, and 7 of this appeal also fail. Then there is the issue of foreign lending in Uganda. It therefore falls on this court then, as the apex court in our jurisdiction, to conclusively pronounce itself on the issue of illegality as a point of law, which has been raised right from the trial court up to this court, and thereby avert the inordinate delay and consequential injustice that the parties would certainly suffer if the matter were referred back to the trial court. But its decision were again appealed against up to this court. The determination of this issue will resolve a core point of law in this appeal, and also render clarity on the position of the law with regard to persons in Uganda carrying out financial transactions with foreign financial institutions or persons. This will enable the banking and other financial institutions transacting business in or with institutions in Uganda carry out their businesses with certitude in the knowledge that they are secure under the law. Then it goes on to make further analysis, but I will not read that. Then I proceed to read. By no stretch, again it is on ground 3, 4, 5, 6, and 7. By no stretch of construction could the type of agent banking provided for in the Financial Institutions Act of 2004 as amended, and the Financial Institutions Agent Banking Regulations 2017 made thereunder be applicable to the agency relationship obtaining between the first and second respondents herein. This agency relationship is between a foreign financial entity, that is the second respondent, which is not registered or carrying out financial institution business in Uganda, on the one hand, and a financial entity, that is the first respondent, registered and carrying out deposit-taking business in Uganda, on the other hand. The second respondent is not the type of principal bank envisaged under the 2017 agent banking regulations, since it is not licensed to carry out financial institution business in Uganda. Similarly, the first respondent was not the type of agent envisaged under the agent banking regulations, which only provide for humans operating outlets as agents of financial institutions licensed to carry out banking services. The type of financial transactions entered into between the first and second respondents is otherwise known as syndicated loan facility, which is a global lending phenomenon practiced by local and foreign banks or non-bank lenders. This practice usually stems from the need to spread out and thus reduce the enormous risk associated with lending large sums of money. Individual countries may enact laws that place limits on the amount of money a bank can lend to a single borrower, thus encouraging syndicated lending. See, for example, Regulations 6, 9, 10 of the Financial Institutions Limits on Credit Concentration and Large Exposures Regulations of 2005. With these restrictions, large entities constantly looked for foreign financial institutions, which may be banking or non-banking institutions, for syndicated credit facilities. I will now proceed to the part of the conclusion and the orders. As is discernible from the analysis above, the rights and roles of the agent appointed in the agency relationship provided for under the Financial Institutions Act of 2004 as amended, and the 2017 regulations made thereunder differ markedly from the ones conferred on the agent appointed under the syndicated relationship. The duties of the agent in the syndicated relationship are much wider than that conferred on the agent provided for under the Act and regulations made thereunder. Most notably, a financial institution in the syndicated credit facility arrangement, which is appointed an agent of the other creditors in the syndicate, remains at par with them, because it is, in its own right, also a creditor to the same borrower, which is precisely the case herein. In the instant case before this court, The second respondent is neither licensed nor regulated to carry out financial institution business in Uganda. Hence, its appointment of the first respondent as its banking agent could not have been so done under the provisions of the Financial Institutions Agent Banking Regulations of 2017. Second, the first respondent, being an entity duly licensed to carry out financial institution business in Uganda, could not have been appointed a banking agent of the second respondent within the purview of the Financial Institutions Act of 2004 as amended, and the Agent Banking Regulations of 2017 made pursuant thereto. Accordingly then, the relationship between these two banking institutions and between them and the appellants with regard to the financial credit transactions carried out between and amongst them were neither governed by the Financial Institutions Act of 2004 as amended, nor the Financial Institutions Agent Banking Regulations made thereunder. In the syndicated agency relationship created between the first and second respondents as banking institutions, the rights and duties conferred on the first respondent as the agent bank in the relationship between the two banking institutions makes the first respondent a fiduciary to the second respondent. This is because the first respondent is responsible for the disbursements of the funds from the second respondent to the appellants, holds the mortgaged loan securities in trust for the second respondent, and follows up on the servicing of the loan by the appellants for remittance to the second respondent. I can't see how this arrangement and the transactions that were carried out pursuant thereto could be construed to mean that the second respondent carried out financial institution business in Uganda within the meaning ascribed to the phrase financial institution business by the Financial Institutions Act of 2004 as amended and the Financial Institutions Agent Banking Regulations 2017 made thereunder. Furthermore, it's worthy of note that no law was cited or brought to the attention of this court which forbids the creation of the impugned syndicated agency relationship entered into by the first and second respondents. Similarly, no law was brought to this court's attention that forbids foreign financial institutions from extending credit facilities to any financial institution or person in Uganda. If anything, in furtherance of international trade and investment, financial institutions the world over are known to engage in global financial business transactions by dealing with or through financial institutions based in other jurisdictions. In the case of Uganda, such international financial business transactions are certainly neither governed by the Financial Institutions Act of 2004 as amended, nor the Financial Institutions Agent Banking Regulations of 2017. Excuse me. the regulations of 2017 made pursuant thereto. The trial judge therefore erred in holding that the credit arrangements between the parties thereto were clothed with illegality. This is the conclusion. In the premises then, this appeal would succeed only in part, and I would accordingly make the following declarations and orders. Number one, the amendment of the plaint which introduced the claim of illegality as a cause of action was proper in law. Number two, the syndicated credit facility executed between the second respondent and the first appellant, with the first respondent as agent of the second respondent, is lawful, and neither the Financial Institutions Act of 2004 as amended, nor the Financial Institutions Agent Banking Regulations apply to them. Number three, accordingly, the claim impugning the legality of the credit facility contracts between the parties hereto is disallowed. Number four, the issue of illegality having been resolved in this appeal, High Court Civil Suit number 43 of 2020, between the parties hereto, which was the genesis of this appeal, which was the genesis of the appeal to the Court of Appeal and ultimately to this court, is remitted back to the High Court for trial before another judge, basing only on issues of fact arising from the pleadings. The respondents are awarded 50% of the costs in this court and in the Court of Appeal. Since the other members of the quorum are in full agreement with the judgment and orders, I have proposed above. Judgment and orders are accordingly hereby given in the terms stated out herein, dated this day of June 2023, Alphonse Chigamoy Owinyidolo, Chief Justice, signed. Then there are 4 concurring judgments, as I had stated earlier, of Justice Faith Monda, Justice Percy Tuhaise with myself, Justice Mike Chibita, and Justice Stephen Musota. They are all duly signed. And this judgment, I will repeat, will be sent to you. Soft copies of this judgment will be sent to you immediately. Thank you very much.
We have received the judgment, and the Supreme Court, in its own wisdom, has directed that we should not talk about the issues of illegality, even in the High Court, which we think is wrong, because, as you have seen, we had applied to this same court to adduce evidence of illegality. But the Supreme Court has refused and has said, don't talk about that. Go back to the High Court and talk about matters of facts, whether there was a loan or what. And we are not happy with the decision, but we accept it. We shall go back to the lower court and argue.
And so what can you solve the issue that they are saying that these laws which are governing financial issues, they don't...
In fact, the Supreme Court has confirmed that the transaction was illegal because it is not supported by law. But they say, since it is a syndicated loan, which the same court has not quoted any law supporting it, that it should go ahead. So we have no problem, we shall go and urge your case. We are just beginning. So kakati ensonga muzirabye omusango Supreme Court court esingayo obukulu mu Uganda ega nti okwewola sente okwaliwo tekwali mu mateeka naye ate nti engeri gye bakikolamu ekyo kisobola okuyitawo. So fe tulowooza ekooti ekozeemu ensobi naye tugenda kuddayo wansi nga bwe batugambye tuwoze. Mbutuwoze ku nsonga oba yafuna looni oba nedda. Ebya kubeera nti looni yali nkyamu kooti eno ye esazeewo n'ebyesalira nga tetuwulidde.